So side proposition today sees a problem in the real world. And what this problem is very simple. Because side proposition thinks that in a world where the law is created and owned by society, decisions are being made by the few and the exclusive, when side proposition believes the society has the ultimate say in these matters. And that is what our case line is going to be for today. So what is our definition of serious crimes? Now we think of two criteria by which a crime can be considered serious. One, the harm on the victim is irreparable or will last a very long time, murder, rape, for example. Or the harm occurs on a massive scale, for example, large-scale arson. So, what do we mean when we say we are going to allow them to be tried by a jury? This is our policy. Under the legal framework of our country, a pool of people who are eligible to be members of a jury are going to be selected. And of course, we are going to have some criteria. Usually, most criteria are, for example, a minimum age, for example, 21 years, and a clean criminal record. And lawyers will have access to the general profile of these people, and they can interview and select the jury before the details about the case leak out to the media. And of course, lawyers on both sides of the case do have a right to veto members of a jury if they feel that these people can be biased. No, thank you, madam. And we say that through this process, we will try our best to eliminate bias within the jury. And of course, people can object to being in a jury. So if a person says, I don't think I can make this kind of decision in this sort of situation, we will allow them not to be in a jury. And once, no thank you sir, so once the jury is chosen, we are going to sequester them from the media or any other source of information, for example the newspapers or tabloids or whatever, no thank you sir, that could potentially prove to compromise this person in the form of creating bias. So when we talk about the number of people in the jury and what constitutes a majority, we don't think we're going to specify this. We are going to leave it up to the individual legal frameworks of each country to decide about this. But we say that a judge will be appointed to explain to the jury the legal details of the case, as well as explain to the members of the jury certain precedents which have happened in the past with regard to certain similar cases. So, basically what will the jury do? They will simply listen to all the court proceedings. They will listen to eyewitness testimony, they will listen to the presentation of evidence. And at the end of it, no thank you madam, they will pass their verdict to the judge. And if the decision fits in the legal framework, and if there is a precedent for something being happen, if it's justifiable and consistent, then we say the judge will then decide on the sentence. And if there's let's say an error in legal proceedings, then you say the judge can call a mistrial, and no thank you sir, we'll simply have to repeat the entire thing again. So, what are our two substantives for today? I'll be talking about why what we're doing results in better representation of society insofar as the law is concerned. Or my second speaker, Benjamin, will be talking about why we ensure a greater degree of neutrality than would be seen in cases without juries. So, now to my point about the representation of society within the law. And under this point, I have three main parts. Firstly, I'll take you in a moment, sir, about why the law represents society. Secondly, why having a jury allows for this to happen better. And lastly, I'll be talking about some advantages and refining the legal process. But before that, the gentleman something to say.
You're unhappy with the fact that judges play such a big role in the current process, and yet under your policy, judges do the sentencing, decide whether a court gets to get the hearing, and they decide in the appeal process as well.
Oh yeah, that's fine, because there's a huge difference between a judge deciding who comes into the jury and between a judge, or let's say three judges for example, sitting within a court and deciding what will happen to that person. There's a huge difference, because when the judge chooses members of the jury, firstly, these are not the same judges who are going to be involved in the case, obviously. These are people who are more neutral, considerably more neutral than the people you are going to put in court. And we're not only going to have one judge choose everyone, so in that sense, bias is also eliminated, so we don't think that's a valid contention at all. So let me talk now about why the law represents society. Let's start from the very basics. Why do we have law? The reason we have a codified legal framework is because society believes in general that some things are right and that some things are wrong and abhorrent and should be prevented. That's why we codify these things in law, to make it easier for this to be applied. So when a society bound by a contract like this, if an individual in such a society violates one of these laws or is charged with violating one of these laws, we don't think then that the person who should be applying these codified statements to this person should be a random member or one select person. We think the society in itself should be empowered to make this sort of decision, because the law represents society and its moral standards. And any person who violates the law also threatens at the same time to violate these same moral standards. So why does having a jury better allow for this sort of representation of society in the law? Because side proposition, no thank you madam, thinks there's a sort of permanent lacuna in the law today, and that there's a huge gap between the codified law and how law is applied to an individual who's charged with a certain crime. Because law as it is codified is never perfect. It can never account for every single situation where a person might be charged with doing something that could possibly be considered wrong. So we need some sort of interpreting agent here. But who should this agent of transformation be? If the law was created by society, and society is the one responsible for enforcing these, we think the transformational agent should then be the society. Because we don't think we should arbitrarily empower a person or a small number of people to make this sort of decisions. No, thank you, sir. Because we see that lawyers and the rest of society do live the same sort of lives. They may be subject to the same sort of bias. They listen to the same sort of news and the media. The difference between a judge and a jury lies in the numbers and the sort of mindset they bring towards a case. No, thank you, sir. Because whereas the judge might be more inclined to give a complicated case on a random legal statement or a small or certain phraseology in the law, we think that the society does it in a manner which is much less arbitrary insofar as democracy is concerned. Because what they're doing is that they are now taking the statements they codified in the first place and reinterpreting them and applying them to a situation where they are the people with the authority to make that sort of decision. So what are the advantages of this system? We need to see that over a period of time we create a very positive precedent. Because any precedent, any case that happens in a court becomes a law unto itself. So when society decides to use a certain law in a certain way and apply it to a certain case in a certain way, we say society is once again refining the law by making clearer its intentions as to how this law should be interpreted and used in the context of the society. So over a period of time, as we see multiple cases being brought before different juries, and different juries interpreting and applying this law, we see a refinement of the entire legal process, as the society then becomes the sole interpreter of the law. So on these three grounds, on why law represents society, on why the jury is best suited to apply this to people, and on the advantages we see in the long term, we see side proposition sweeps the floor. Thank you.
Well, let's get the key stance of the opposition today straight, right from the start. What opposition today stands for is that citizens will not be given such a right to be subjected to a trial by a jury of their peers. In other words, all citizens, regardless of whatever crime they are being charged with, will be tried and sentenced by the judge. So before I move on to my two main points of the rebuttal, let me first clarify a few things. Firstly, we believe that the accused already has a full and sufficient scheme of rights. For example, habeas corpus, the right to remain silent until representation by an attorney. Secondly, under a judge system, let's remind the proposition today that judges can be asked to recuse themselves in a case of conflict of interest. In other words, there are methods for addressing conflicts of interest that can happen under our side of the house today, and also under their side of the house today. And finally, what we are pushing for today is not absolute justice that will be wielded through the hands of a judge. We are talking about which side of the house can better fulfill fulfill the role and nature of justice in a modern society. So let's first talk about the proposition's case today. Now I shall attack their case on two main levels. Firstly, let's talk about their policy. Secondly, let's talk about their entire substantive about society and the law. So let's first talk about policy. Now I have something to say about their idea of serious crimes. Now generally their definition of the idea of serious crimes is acceptable. But then let's bring another spectrum to today's debate. They've forgotten about corporate crimes. Crimes that happen to be an embezzlement of public funds. This could also be considered as serious crimes. So in this case, you see the proposition perhaps has been a little tardy in its consideration of the idea of a serious crimes. Well, thank you, sir. Now, Then they talk to us about the jury selection process, and everything sounds fine until we hear this thing, that the jury, those people who are selected to be in the jury, have a choice to reject being in the jury. Now let's think about it. Let's say if one of us here, were chosen to be in the jury. Let's keep in mind that you are being asked to sit through lengthy court proceedings without any form of pay or compensation. What do you think would be your natural response? Will you accept it because you feel that you need to fulfill your responsibility to society, or do you think that you reject it because you have better things to do with your time? And in this case, the choice is obvious. Obviously, if you give jury such a choice, they will take the choice. Then it's about sequestration. No, thank you, sir. Now, we need to remind them that sequestration is not a foolproof process, and they seem to have forgotten to make room for such a possibility in this case. Yes, you can keep the jury in the hotel, make sure that they don't watch TV or receive phone calls. But what happens when a protest erupts right in front, outside of the hotel? And in this case, we see that sequestration does not always ensure the neutrality and the objectivity of members of the jury. And finally, when you think carefully about their policy today, their policy is a very half-baked one. Because at the end of the day, the judges still have a very vital role to play in the proceeding of justice. As my third speaker raised in the POI, the judge still has to say over whether or not the case gets heard by a jury. He still has to say over what kind of sentence to implement upon someone who has already been charged as guilty. And finally, and most importantly, the judge has the say to overturn the judgment of the jury, which makes the judgment of the jury irrelevant in this case. No, thank you, sir. In this case, their judgment by the jury is a tokenistic one. Because the judge can simply go out there and say, well, I think this is a mistrial and quote some sort of technical principle upon which the jury has failed to fulfill. And the jury will have nothing to say about this. No, thank you, sir. So at the end of the day, we see that policy has various multiple loopholes which they haven't really managed to patch up within their proposition speaker. Then let's talk about society and law. Now let's keep in mind a very important distinction that we need to draw right from the start. Legality does not necessarily equate to morality. Society may have certain moral views on certain issues which are not codified in the legal framework of a society. Because perhaps the legal framework feels that as long as third-party harm is not being caused, there's no reason to put, for example, prostitution as a crime or abortion as a crime. And in this case, you see that proposition seem to have conflated the two a bit. They seem to think that morality, the moral views of society, must definitely be represented by the laws of a nation. And this may not always be the case. On the second level, they talk about, to us about the need to fulfill society's demands for the law, about how society creates the law, owns the law, and therefore it should have a duty to implement the law. Then we tell you the answer is not the jury system. The answer is to make sure, no thank you sir, that the judge follows the very letter of the law. To make sure that the judge is accountable for the various judgments he makes, and not simply to sweep the judge out of the courtroom and say that we should have a separate system, but at the same time we don't really respect this system. No thank you sir, we don't really respect this separate system because now the judge still has a vital role to play in the courtroom. And then they came out and talked to us about the difference between a judge and a jury. They tell us that our judge is about numbers. Now we disagree with them, and I'll show you later on in my substantive. And finally, about interpretation. Now, it tells about how juries somehow can be better at interpreting the law. We tell you, no. Judges are also human. When judges make a sentencing or they make a judgment on a certain case, they keep in mind various factors, mitigating factors, but emotions, crimes of passion. These are things that judges can do as well as the jury system. So now that I've shown you how their case completely falls flat on its face. Yes, sir.
So these are areas of subjectivity. That's the reason why we want a bigger jury.
Now, sir, the only thing that I can think about this is that when you have more people who are more subjective, it's only going to increase the element of subjectivity in the courtroom. Where you have a judge who's trained to interpret the law, to understand the law, and to execute the law. Versus a group of people who come from the public who are unwilling to even carry out jury duty in the first place, who are not trained at all. Who do you think is better able to implement the word of the law? So now, I'm supposed to be talking to you, we'll be making a very basic comparison between judge and jury and show you why ultimately a system of judge is better than a system of jury. My second speaker will be talking to you about the issue of legal consistency. So now the framework of my substantive today is very simple. First, I'll talk about the jury, then I'll talk about the judge, and finally I'll do a compare and contrast, somewhat like a history essay. So in any case, let's first talk about the nature of the jury. Now the jury lacks legal training. But let me forward this by saying that it's relatively straightforward to make a call on a case if the case is simple. Like say A murders B, therefore B should get a punishment. No thank you, sir. But then the question is, what about complex cases where there are multiple charges of murder, of assault, of rape, all clumped into one case? Do you think the jury is able to make a fair call on such an issue, especially when they lack the legal training? Legal training entails the understanding and appreciation of things such as legal principles, legal technicalities, and these are things that the jury lacks. Sir, no thank you, sir. The second thing to talk about the jury is that the jury is susceptible to unqualified influences. For example, they can be emotionally swayed. They are more exposed to the various devices that can be manipulated by lawyers outside the letter of the law. So allow me then to move on to the second role that I talked about, nature of the judge. The most important thing, the judge is accountable. There are various mechanisms in place for addressing the incompetency of the judge. If a judge is unable to make a fair call because of conflict of interest, the judge can be asked to recuse him or herself. This cannot be done once the jury pool is decided upon, once the jury sits in a courtroom. Secondly, the judge is trained to devoid themselves of personal beliefs. This is not necessarily saying that they are totally separate. No, thank you, sir, you're out of time. This is not necessarily saying that they are totally separate from their value system. But what this is saying is that they are more objective, they are able to weigh their personal beliefs against that of the law. So let me now then do the compare and contrast. The law requires people and interpretation to be fair, consistent, and accountability. And we tell you today that the jury system accomplishes this to a lesser extent to the judge system. Because you see, on fairness, judges have the legal training, juries do not. On accountability, judges are accountable, juries are not. And on consistency, this will be what my second speaker will talk about. Therefore, for the sake of implementing and executing justice fairly and consistently,
I have 3 points of contention for today. First of all, on the substantive of comparing judges and juries. Second of all, on this whole idea of how there's no relation between morality and legality. Third of all, on their attacks on our policy. So first of all, they talk about comparison between jury and judges. So what have they said about that? First, they say that juries lack legal training and there are complex cases where they cannot decide on something. Now I have 2 things to say about that first. First of all, you don't need that kind of extensive legal training to decide if a person is guilty or not. And even if you need some amount of legal information, we've already provided for provisions of it in our policy. Because we've already told you that there will be judges and there will be individuals in the courtroom who are able to assist the jury and tell them things that they need to know. And they can assist them through the process. But we say that they don't make the final judgment for the jury, they empower the jury with more information so that they are able to carry out their duties properly. So we say, ladies and gentlemen, that no, it doesn't matter that they have no legal training. We say that deciding whether a person is guilty or not is a simple matter of evaluating the evidence and seeing that if this person really indeed committed a crime. So we say that no, thank you sir, that this jury does not need that kind of legal training that you're talking about because it's just about a verdict, it's not about a sentence, it's not about complex little things in the law. Lawyers will explain it to them, people in court will explain it to them, the judge will explain it to them. So on this whole second, I then talk about how juries can be manipulated. And then I ask you, can judges be manipulated? Yes, judges can be manipulated. And in fact, in general, anyone can be manipulated. Which is why we have a system of appeals, a system of mistrial, so that we ensure, no, thank you madam, that if there is something that went wrong in the system, where someone is observed to have been manipulated, or someone is not satisfied with the verdict, this can be called up for appeal later, either in a higher court or in the appellate court. So we say, ladies and gentlemen, manipulation is not an attack on our point. Then they talk then about how the judge is better because the judge can be unbiased and that the judge can recuse himself. What about judges who are unaware of a subconscious bias that they have towards certain crimes? What about judges, ladies and gentlemen, who don't want to be recused because they want to sit in that trial, because they want to make that unfair judgment in that trial? We say that your policy of recusement of judges does not include a third party to check on the judge. Do you expect lawyers, well thank you sir, to tell the judge that I don't want you in this courtroom? Do you expect the defendant to tell the judge that I don't want you in this courtroom? Clearly, this won't happen. And we say how? When they say the judges can be unbiased as if a judge were a robot. No, a judge is still human. There will still be bias in the judge. The question then, no thank you sir, is how do we minimize the possibility of bias? And we say that we are not going to assume that a single individual, just because he has legal training, will be unbiased. We'd rather have safety in numbers and a safety in composition drawn from the layman on the street where bias is minimized. So we say that point of substantive, how they say that judges are better than juries is false. So now let me talk about my second point of contention. They talk about their policy, or rather their attack, no thank you madam, on our policy. So first of all, they talk about how we have a very unclear idea of what a serious crime is. No, we do have a very clear idea of what a serious crime is. Serious crimes, as explained by Ashish earlier, are crimes that involve either severe harm to the victim or result in a very severe sentence. We say, and Ashish has already said this, that when there is a serious crime, this will be decided upon a country. And generally, countries do have a classification of crimes, where some crimes are more serious than others. I'll give you the example of France, where they made a classification between a felon and an offence. And as a result, felons are crimes that are more severe in nature and hence necessitate a jury in France. So we say that countries can make this kind of decision. They do make this kind of decision. No, thank you, sir. And then they talk about how people won't want to sit on juries. Now, if people won't want to sit on juries, then why is our jury policy, which is actually similar to the jury policy of the USA, have people sit in their juries, ladies and gentlemen? We say that people do sit in juries. People, no, thank you, madam, in the US do have an option to not sit in the jury when they are called out for jury duty. So, ladies and gentlemen, we say that people do sit on juries, and we say that that attack is false as well. And then they talk about how our policy is our policy of sequestration is not foolproof, because they talk about how there could be a protest in front of the hotel, or how there will be how the people will not, these measures not foolproof. First of all, they considered, when they said maybe we could block out television and media successfully, they considered that some part of their sequestration policy will be successful. Second, I ask you, if there's a protest in front of the judge house, wouldn't the judge also be affected, ladies and gentlemen? We say that they have not shown us how judges, thank you madam, are systemically better than a jury, other than the fact that they have legal training. I tell you, there are thousands of judges out there who probably have some bias within them that they are not even aware of. So we say, ladies and gentlemen, this comparison between judge and jury, no thank you sir, is still false. So we say that yes, they still can be affected. And then they talk about how the judges in this situation are still involved. And we say that judges are still extensively involved. Well, judges may still be extensively involved, but the most important part, is he guilty or not? That part that determines whether the person will go to jail, the person will be hanged. We say that that part is still left to the jury, and that is a really, really big thing. We say that we take a lot away from the judge just because they can't declare a person guilty or not. And now to my third point of contention, thank you sir. They talk about legality and morality, and they say that morality and legality aren't necessarily the same. We say, ladies and gentlemen, the very fact that we have a democracy where people vote for who they want into power, where people effectively have decision over what laws are instituted in their country, is a sign that people translate their moral values into the ballot box, which is then instituted as laws in their country. So yes, legality and morality are related in this sense. Furthermore, we say that judges being trained in the letter of the law is not necessarily relevant, because we say that there are a lot of grey areas in the letter of the law. The law is never perfect. There are grey areas and instances, hold on a moment sir, where we're not sure when it can be applied. Yes sir.
You're telling me that a group of untrained juries can make a better call than a legally
Thank you sir. Let me explain what a grey area is. A grey area is, we're not sure if this falls under one side or the other. Let's allow society to choose whether they think that the action the person has done is wrong, because ultimately a verdict is deciding if what the person has done is wrong. It's not about the technicalities of it, it's whether or not what he has done is wrong, and that judgment should be left to a jury. So we say, ladies and gentlemen, no, they don't need the expertise, judges are equally biased, so we say that all their attacks fall. So now we need to move on to my point of substantive. We have to understand today, serious crimes means there are serious offences. And as a result, the burden of proof has to be higher, because we don't want to unnecessarily sentence an individual the wrong way. We don't want to condemn him to a life in prison or to the death penalty unnecessarily. We want to make sure that as far as possible our legal system is watertight. How is this achieved? This is achieved in neutrality in court, where the decision maker as to whether or not the person is guilty is neutral. How is neutrality then achieved by a jury? This neutrality is achieved by a jury in two ways. First of all, there is neutrality in numbers. Why? Because when there's more people, it means you need to convince more people that this person is guilty. Second of all, there's neutrality in composition. Because lawyers on both sides can deselect individuals from the jury, we say that they will naturally minimize the bias within that jury. No, thank you, sir. So we say that is where neutrality in composition comes in. But what about the judge? The judge is not necessarily more neutral. In fact, it's less neutral than a jury. Because when you have a panel of judges or a single judge, it's even smaller. All you need to do is convince one man that the guy is guilty. Second of all, it's hard to contest who is the judge that is trialing your case. Other than the judge recusing himself, which is an act that the judge has to do on his own, there's virtually no other way that you can do it. Are you going to accuse the judge and say he's biased? Are you going to go up to him and tell him that this is a sham court, this is a kangaroo court? No, ladies and gentlemen, clearly this will not happen, and judges with most of their political connections will prevent this from happening. So we say at the end of the day, ladies and gentlemen, it is absolutely clear. Neutrality is necessary, because this is an individual that we could be sending to jail for 10 or 20 years. This is an individual that we could be hanging next month onwards. So we say, ladies and gentlemen, that because this individual is potentially facing that harsh a penalty, we need to ensure that when we decide whether or not he is guilty, we have the most neutral party possible to decide whether or not he is guilty, because it is only fair to the potential criminal. Thank you.
One thing we are all clear. We are dealing with human beings. Human beings who are susceptible to influences which cannot be completely blocked on both sides, as we agree. Human beings who all have personal beliefs. conscious or subconscious. The real question is, who, the judge or the jury, can get over these beliefs, the nature of being a human being, to uphold the spirit of law in objectivity, in fairness? Now, I say the answer is the judge. And I'll prove to you this in my contentions. First, to question the proposition's policy. Second, to question representation in law. And finally, to question fairness in law. So first, let's look at their policy. The first question we asked them in the first speaker is, will you even get a jury in the first place if you make it optional? Because my first speaker has put forth to you that trial is a lengthy process. It may not be the most interesting process. And really, ladies and gentlemen, jury have a job. Jury could be the typical middle-class person on the road, no thank you sir, who cannot afford to spend months in your court. And then they say, oh, in America it's all fine. Well, you know why it's all fine in America, ladies and gentlemen? Because America makes it a national responsibility. They say it's your duty as a citizen to go to jury. They make it compulsory, ladies and gentlemen. That's the only way you can do it. And if you don't make it compulsory, you will not have a jury. All sorts of principles they stand for do not stand. And on the second question, no thank you sir, the next question we have to ask is, they talked about selection of the jury process, how lawyers have the ability to veto the jury. Now we want to say it's precisely this selection that you actually advantage the rich in the process. Now in every single country, we want to put forth to you that there is going to be wealth inequality. Some people will have more ability to hire better lawyers, and the problem is if you have the jury process section, people with more legal resources will be able to better analyze the jury. You exacerbate the disparity of wealth when it comes to your legal system. You undermine justice for factors which should be completely irrelevant. And on the last tier, I also want to bring on a new attack to their policy by asking you today, is it fair to make a jury take on the burden of sending someone a death sentence, for example? Is it fair to put that on their conscience? We say it's difficult. If you want to ask a jury to sentence someone guilty of murder, it would stay on their conscience forever. It may affect their ability to make a fair decision, to properly assess the guilt of the person. We say don't put on this on their conscience, it's unfair. So having dealt their policy, let me move on to the next point on representation in law. Now, how is representation achieved? Both sides of the House agree through the making of the law, because we get to elect our representatives, and on this count, we get to decide what is illegal and what is not. And the next question then is, do we need representation in the interpretation of the law? Now we say no. Why so? Because judges have the incentive to adhere as closely to the spirit of the law as possible. As I put forth to you in my next contention, they have the technical expertise to understand what the spirit of the law is, and they have an accountability to their legal profession to uphold the spirit of the law. In contrast, in fact, for the jury, they may not always agree with the law. We all concede in democracy, laws are created by the majority. What happens then if you have a minority who does not agree with the laws against prostitution or the laws against abortion? What happens then is that you allow the exertion of personal morality onto your legal system. You undermine what society has collectively decided. And then we want to talk about judges. Yes, judges have personal moralities as well. But who is better able to prioritize the law of the land above your own personal morality? We say it's a judge. The judge with legal training. Hang on a minute, sir. The judge with accountability to the legal profession. Yes,
It has nothing to do with abortion or religion. It's to do with things like murder and rape, which everyone in society agrees upon as a moral standard.
Well, sir, let's just face it today. They may not agree with the sentencing. I've given you the example of the death penalty. They may not agree that someone who's murdered deserves to die. And because of that, it can also influence what sort of verdict they pass. And let me move on then to my last point of contention on the idea of fairness. We want first to put forth to you two clauses we've clarified today, that there's room for recuse of judges if lawyers do believe they are unfairly influenced. No, thank you, sir. And secondly, it's entirely possible we have a panel of judges for serious crimes. All their points and numbers do not really stand. And then they talked about how numbers give us an advantage. We've already showed you can match them on numbers, but more importantly, how important are numbers? We've put forth to you in my first legal substantive that first, judges are less easily swayed by persuasive lawyers who have been through brilliant legal training. And on another level, they have better technical knowledge. And why is this important? They say it's entirely not important. I say it's important for two reasons. First, because they know how to accord the right weight to different facts, which may not always be clear in every case. And second, because they know the weight of each mitigating factor and how much it should play in determining guilt. This is not something that's always clear-cut. That is why we have spirit of law. Remember, ladies and gentlemen, in passing a verdict, we want judges to uphold and pass a law based on what the law intended, based on what the spirit of the law was, rather than on a case-to-case basis. And I'll show you the importance of this in my point of consistency. And in fact, we have an opposition who's already conceded to the competence of judges. How so? First, because they allow the judge to explain everything to the jury. Now, I see a large propensity for the judge to influence the minds of the jury right at that point. And therefore, this already concedes that judges are competent. And on the second level, because as my first speaker put forth to you, judges are existent in all layers of the court, in the process of appeal, in the process of determining whether anything can go to trial. And finally, because judges are able to overturn decisions and call it a mistrial. Now, ladies and gentlemen, giving so much power to a judge, we say there is a concession about the competence of judges. So having shown you that, let me move on to my substantive on ensuring consistency of law. Why do laws have to be consistent? Firstly, because this ensures fairness. This ensures that for two trials with similar circumstances, that the exact same verdict is passed. And secondly, because we believe there has to be one rule of law for one country. You cannot have two different laws passed on two different cases. Yes?
Madam, we say that the jury can have consistency in their verdict because the judge guides them through it, people guide them through it.
I'll show you why the jury cannot have consistency now. That is why it's my substantive, if you wait for a short while. And the last reason why we want consistency is because it's fair to everyone in the country. If you have a single law, a single rule everyone plays by, it's fair then that they use these rules to guide their actions. And how is consistency undermined by having a jury? First, simply because all law works on the basis of precedence. This is how we ensure consistency in our law. The only way laws are consistent, the only way verdicts are consistent, is if judges always refer to previous cases, look at how they were ruled, and then decide on how this case should be ruled. And the problem is that the emphasis given to precedents will be reduced when we have a jury. Why so? Because juries are more likely to judge each case based on what they think, each case based on their personal beliefs. If I feel that you don't look so guilty, or if I feel that, oh, it was right for you to murder someone because you know that person slept with my wife, for example, then the jury will just ignore all sorts of precedences and go ahead. And really, we are not saying every jury is not going to be consistent. We are saying the possibility of inconsistency is higher. And given that, for the sake of law, go with the opposition.
I have 4 main points of contention today. First, I'm going to talk about how Ashish's substantive on how the representation of the law, representation of society, has not really been dealt with, but at this point, by the side of the opposition. Secondly, I'm going to move on to talk about the first opposition substantive on this whole idea of how a jury is inferior to that of a judge. And last but not least, I'm going to deal with the substantive or the second speaker on the whole idea of consistency of laws. But before I move on to all these issues, let me first take a look at the policy, the text which the opposition has brought up today. The first main point that they talk about is how, in this case, the inequality of wealth and so forth will lead to how the individual will be given an unfair trial. Ladies and gentlemen, we need to realize there is a factual inaccuracy because in these cases, it's more often than not, it's the state versus the individual. So given this knowledge, ladies and gentlemen, I really do not see how the whole idea of the lawyers being rich, hiring richer lawyers will get you a better jury is going to help the case. Secondly, ladies and gentlemen, they talk about how the judges can exclude themselves. But ladies and gentlemen, this is a point which they never really had a response to. Because we need to realize that whenever we have a criteria, we need to have an enforcement mechanism. But in this case, this enforcement mechanism lies in the individual himself. And no thank you, sir. And we say that if the individual were to abuse, in this case the judge were to abuse this check and balance, who is to stop them from going there? These are the questions which they never really came up on. And I really think that the opposition needs to swap sides with us because their role is to engage with us, to respond to us. No thank you, madam. So ladies and gentlemen, now we're moving on to the main substantive areas in today's debate. The first question is whether or not there is going to be a better representation of society. First, ladies and gentlemen, let's take a look at what they really say. In this case, ladies and gentlemen, they talk about the conflation of legality and morality, and they say that the legal system should not be confused with the moral system. But let's remember the fact that we are already giving the people the right to make laws, ladies and gentlemen. That goes to show that their moral system beliefs are already codified in the law. So if your fundamental attack on the case is how we should not confuse the legality and morality, we need to realize that that is a contradiction, because you are already giving the people the right to decide which laws they are going to be implemented, which laws are going to be codified in law. Secondly, ladies and gentlemen, they talk about how the judges need to follow the law letter by letter. But then we realize in the second speaker that they start talking about how the judges should follow the spirit of the law. So ladies and gentlemen, if a law has a spirit and if the law is a series of letters, we say there is really a contradiction in what the first and second speaker is trying to say. Because are you going to strictly follow the law sentence by sentence, or are you going to allow for discretion to be put in place here, ladies and gentlemen, when it comes to the spirit of law? So in this case, we need to realize that the ultimate point of this, no thank you sir, is this: that the role of judges is not completely technical. They need to consider mitigating factors. And in these cases, ladies and gentlemen, that is when the technical role is not sufficient enough in order to make these objective decisions. And that is why we want Benjamin substantive here. That's the reason why we need neutrality in numbers and neutrality in the composition of this jury here. So ladies and gentlemen, no thank you madam, in the contradiction between the first and second speaker, we see a greater point here, that there is a vacuum, there is a space for the jury to be present. Then they say, ladies and gentlemen, that we have a contradiction over the competency of the judges. There is really no contradiction on the start of the proposition here. What the proposition is basically trying to say is that the judges and the jury can play complementing roles here. The judges, ladies and gentlemen, can give the technical expertise that is required. In this case, ladies and gentlemen, the judges can explain the legal details, the legal jargons that were being put forth by the lawyer. No, thank you, madam. And so, ladies and gentlemen, if the judges are as responsible, no thank you, sir, as responsible and as professional as the opposition would want to believe, we generally believe that the judges will be able to give a very comprehensive briefing of the jury. And that is when, ladies and gentlemen, when the cooperation between the judges and the jury, that is when we get a better and a more neutral verdict. So that, ladies and gentlemen, is really what Ashisha Substantive is about. That we really want to represent society. And representing of society comes in three main ways. Firstly, the codification of the law. Secondly, the interpretation of the law. And last but not least, the refinement of the law. Ladies and gentlemen, it's very important for society to be involved in this case, because like what the opposition said, that no thank you sir, that more often than not, our current laws are built upon case precedents of previous laws, ladies and gentlemen. And that's the reason why we need the people to be part of the judging criteria, or the judging process here. Because if the people are able to influence the results of a court verdict, ladies and gentlemen, they are also able to influence the laws that are going to be made in future based on these law precedents. And that is why the representation of society is so important. If we have already included them in the codification of the law, we need to, no thank you sir, need to further improve or extend this right to interpretation and refinement of law. And at the end of today's debate, the opposition has failed to answer this question. Why can't the interpretation and refinement of the law be a democratic one? That is something the opposition has failed to really provide a logical explanation. Yes, madam?
Would you rather the interpretation be based on a personal morality which may not agree with society's morality, or a judge who will try his best to go according to the spirit of the law?
Madam, you need to realize this. That when we come to possibilities, when it comes to chances, it's more possible for us to have a judge that has a minority view as compared to having a large jury of people all having minority views here, ladies and gentlemen. If you do your mathematics, this is obvious. Because in this case, ladies and gentlemen, the possibility of a judge that has errant or that has a less popular moral belief system is higher. So ladies and gentlemen, I'm moving on to the second main point on the substantive which the opposition talked about, on the consistency of laws. Ladies and gentlemen, the reason why we call them two court cases, because they are different by nature. How can we have the exact same verdict, ladies and gentlemen, for cases after cases? What is the purpose of a trial then, ladies and gentlemen? We need to realize that the laws are generally written because they are a general guideline of what society thinks is right and wrong. But the application and interpretation of which laws should be applied, which laws have been infringed upon, needs to be settled in the court cases. So in the case of consistency of laws, ladies and gentlemen, your point simply does not stand because you do not understand the complexity of the legal system. No two cases are exactly the same. Neither can we arrive at the same exact verdict. No, thank you, sir. So in this case, ladies and gentlemen, we need to realize that at the end of today's debate, consistency is not the point. But last but not least, let's take a look at Benjamin's substantive here. Benjamin substantive talks about the neutrality of laws in terms of composition, in terms of numbers. Have we heard anything that opposition has said to that? Ladies and gentlemen, honestly, we have not heard anything from that. And in this case, why is the fairness or neutrality of law so important? It's because we are talking about serious cases that involve serious punishments, ladies and gentlemen. You cannot have an error of judgment, have the punishment being meted out. Ladies and gentlemen, these punishments more often than not include death penalty, include corporal punishment. The effect of the punishment is irreversible, ladies and gentlemen. And that is why the neutrality of the law needs to be put in place. But the exact mechanism which Benjamin has proposed here has never been dealt with by the side of the opposition here. So we think there is a concession by the side of the opposition that in our case, the jury system is superior as compared to having the decision left to a judge. So at the end of today's debate, we need to realize one thing, that judges are human, juries are also human, ladies and gentlemen. What is the difference?
Feels like standing in front of the Supreme Court right here, even before I became a lawyer. But really what I want to think about what goes through judges' minds, especially those in the Supreme Court, is how best to apply the letter of the law, and yet at the same time to take into account some of the changes in terms of the societal values that have undergone in terms of society. This leads me to my three questions for today. Firstly, what's the best way to represent these societal values? Secondly, what's the best way to ensure a fair trial? And lastly, how do we best protect the sanctity of the legal system? Now the prop today says that the law is created and owned by society, and their sole grievance really, or rather their dual grievance, is that of implementation and that of interpretation. Now I want to deal with these two items about implementation and interpretation. Now first, implementation. The best way to ensure that there's an implementation according to the letter of the law is to allow this to be done by judges. Why so? Because judges are best trained not to let their own values override it, and judges have the expertise to do this job, to follow what Parliament has set up and what has been agreed to by the people. Now you oppose this to society, or rather because it's a jury, it is a slice of society and not society as a whole as codified in Parliament's laws, who are willing to override these laws in order codified by the majority when they are swayed, for instance, by the rhetoric of the lawyers, when they are overly swayed by their emotions, something that judges are best able to control. Now when we move on to the second idea, the idea of interpretation, we say in order to account for a changing society, there's always a way for judges in the current system to take into account changing views. All legal systems allow amicus briefs to be brought to the judge to learn and to get an insight into what society's progression towards trends are, and they always take this into account when they make their own rulings. Furthermore, one can always propose to judges to take a look at the current situation or the current context of society and to make a judgment in light of this view. In the Florida Supreme Court, for instance, lawyers argued that the death penalty was against public opinion, and judges took that into account when they make their rulings. Judges can always take these changing natures of society into account. Now, the important thing to note is we always want this interpretation to be modified and to be moderated. I say that judges are best able to ask what is the spirit of the law, what is the spirit of the letter of the law. Let me define to you what the spirit of the letter of the law is. It is what the law intended to do when it was created. And judges are best able to interpret what this interpretation is and to implement it within your own judgments. Now, having dealt with that, let me move on to the second issue today. What is the best way to ensure a fair trial? I want to talk about biasness, about how the rich are advantaged, and I want to talk about gray areas. Now firstly, on biasness, I say there's a fundamental check and balance on judges that is not present on juries. Just because on juries you get a group of people off the streets, you assume that your biasness is reduced. Especially since the proposition has to us today, they're getting them off the streets because they want them to be subjective. A strange contradiction on their part. Most likely, these people are going to have even more subconscious biasness, and they're even going to be even more apparent, and this cannot occur because they do not have the legal training that is present for judges. Now, we say that this problem is exacerbated when you only have the process of voir dire, for instance, the process of vetoing. The problem with this is that rich people can get good lawyers and can get jury consultants who can assess which person is most likely to enter a verdict that is disfavorable towards their client. They're able to cancel and veto out people who are disadvantaged by this. I think the difference between this and the current system is, for instance, assume you have a jury member who is racist in the O.J. Simpson trial, for instance, and you say a judge would immediately cancel him out. But if you were defending counsel, for instance, you would not cancel him out immediately using your voir dire option. You will not veto him out because it's advantageous to you and it's favorable to your client. Judges will do something that's fairer and more closely linked to the letter of the law. And this is not present in the jury system, and lawyers and the voir dire system simply cannot hope for this. Now, furthermore, I say that the subconsciousness that rich people are also advantaged. They came up with the response that it's because all cases are going to be the state versus the individual. But I don't see how if you're going to be charged by a crime of death penalty, for instance, you can't hire a lawyer from Raja and Adam McDaniel. No offense, Raja and and this leads to the idea that you can always get rich lawyers who are very good with rhetoric, lawyers who are better able to sway the juries, as opposed to a judge who has legal training, who is able to look more closely to the facts of the case rather than the rhetoric of the lawyers. Now, having said that, let's move on to judges then, and the idea that there's a check and balance on the subconscious biasness. I already told you that this subconscious bias is more likely to be taught due to legal training, but more importantly, there's a check and balance. What is the check and balance? Is that if lawyers detect there's a subconscious bias, they can always bring up to the appellate court and overrule this verdict. And more importantly, it is possible to detect this bias because it's a record of judging for judges rather than for juries, which you just pick off the street. If you look at presidents of these judges, it is possible to put forward a case to the Supreme Court or the appellate court that this judge has a history of judging in this favor to your client, and there's a possible bias towards it. And I say this is the fundamental check and balance on judges who do this as a profession rather than a random duty that's been selected and forced down on them. Now, how about the idea of the grey area? I want to briefly mention that let's just remember that you're just getting a segment of society to make a judgment call or what side of law an issue falls upon. And as stated by my second speaker, what happens when you have a situation where they cannot agree with it, when it disagrees with the majority opinion, you say that's not following the spirit of the law, that is not resolving the grey area. Now, let's lastly move on to the last issue. How do we best protect the sanctity of the legal system? And in this, I want to talk about precedents and I want to talk about consistency. Now, on one hand, they do not want them to be precedents. Yes, sir.
So you need to realize that judges with their rich wealth of experience, they become disillusioned and cynical of things. And more importantly, your speaker said that if you keep convicting people, in the end, your conscience will be so heavy that they are unable to make a better decision.
I'd like to point out to you that these judges with a heavy conscience and a jaded outlook in life are the same ones they are going to advise your juries in terms of technical expertise. They're going to advise your juries on what this certain legal term means. And I say that in this same way, they are going to influence the juries as well. The biasness is going to be carried upon on the jury system. I say the judge system is best because you have a check and balance on the judges. You can oust them if you feel that their record of judging, for instance, is wrong and is biased, and there's no such fundamental check and balance on the jury system. Now let's move on to the idea of precedents. On one hand, side proposition tells us today that they do not want precedents because they say of evolving nature of the law. On the other hand, they want new verdicts issued by juries to form existing precedents. And I simply see there's a fundamental contradiction in this. Do you want a precedent or not? Or do you simply want just new cases by verdicts by juries that will continually reinvent what the precedent is going to set? I say judges are the best ones to be able to interpret what a precedent means in terms of the grey areas. They are best able to follow these precedents on the first case, on what was the first precedent set for them. And the first precedent was set for them in a law in Parliament, which is the codified views of the majority towards societal values. Now, having dealt with that, let me move on to the second point. Yes, sir.
So in this case, in terms of precedents, why would the jury want to contradict the previous precedent? You can never explain to us in 3 speeches.
Sir, you have to ask today that the very reason why you want to include juries today is because you want to reinvent societal values. And you want them to contradict previous precedences because you have said today that judges are just simply going to apply precedences. So I think it's really your duty to show me why is it that reinventing this idea of precedent is always going to be a good thing in terms of having juries reinvent it rather than having judges interpret it. Now, having dealt with that, I want to deal with the entire idea of consistency. And I think that the best way for us to deal with consistency is to allow judges to apply it simply because judges' technical training to do so, and because judges, having gone through law school, for instance, or having judged numerous cases, are aware of the different specificities of each case, and they can apply this expertise to each different case. So having dealt with all 3 spheres, in terms of that the judge system is the best way to represent societal values, the judge system is the best way to ensure fair trial, and it best protects the sanctity of the legal system, I say go to the opposition.
Now let's try to think about this a little more carefully. If one of us here were part of this jury system as proposed by the proposition today, what would be our first reaction? Would we accept it because we feel that we need to fulfill our responsibility to society, or will we reject it because we feel that, for one, we cannot deal with the responsibility of having to deal out huge punishments, life imprisonment, death penalties in these criminals? On the second level, let's think about it pragmatically. When you know that this trial is going to take you up to, say, 3 to 6 months, would you rather spend your time in a courtroom listening to lawyers yabber at you, or would you rather go out there and do your job and earn some money for your family? Now the choice is very simple, and this is the fundamental question which the proposition today has never managed to deal with. But in any case, allow me to analyze today's debate in three main themes. Firstly, fairness. Secondly, accountability. And finally, consistency. So let's first talk about fairness. The proposition came up here today, and it dared to say that legal training is not that important. We understand our proposition, we show you on various levels why legal training is of utmost importance. Now, even though all three of us, we may have made legal training sound a little bit like boot camp, but essentially what is it about? It is about knowing what principles you should abide by when you are functioning in a court of law. In other words, assigning different values to different evidence or different mitigating factors. We cannot assure this on the side of the proposition. The proposition is unable to ensure that juries will be consistent in its assignment of weight of evidence and weight of mitigating factors. Then the proposition comes out and says that it's only fair that society is represented through a slice of society who sits in a jury box and decides whether or not someone is guilty or innocent. Now we tell today, just because society owns this law, it creates this law, does not put them necessarily in the best position to implement and to execute this law. This is what, throughout all three speakers, we've been saying to them. They have never responded to this. Moving on to my second area of clash, accountability. Now, when we came up with the idea of accountability, about the various mechanisms in place to ensure responsibility on the part of judges, their conduct, their judgments, what did the proposition say? They never did say anything. But what did they say? What they did say is that, well, perhaps they could be accountable, perhaps they would be responsible in their dealing out of judgments. But we on the side will show you overwhelming evidence as to why the judge can be held more accountable, therefore meaning that the judge is more likely to make a fair, justified, and consistent judgment because they have a check and balance against them. Records, for example. And on the other hand, we see that the proposition never did come back to us on this. It seems as if they've forgotten the entire issue of accountability. Is it perhaps something to do with the very nature of jury which they are unable to answer for? That juries are inherently unaccountable. And this is perhaps why the proposition today has failed to answer us on the question of accountability, which is very so important when it comes to dealing out punishments. Punishments like life imprisonment and death penalties to these people who are charged with committing certain serious crimes. Finally, on consistency. Now we understand our position showing the link between consistency and fairness. How consistency will ensure that verdicts are fair. No, we are not saying that verdicts should always stay the same. Anyone accused of murder in the court of law should always be guilty as charged. What we are saying is that judges have the legal training to go in there, think about past precedents, and think whether or not this precedent, the principles embodied and enshrined within such a case can be applied to this current case. Juries cannot do so. For the very simple reason, juries do not apply the same value which judges do to the weight of evidence as provided by precedents. And in this case, the proposition comes out here and says that, well, we want them to use precedents, but at the same time, we want them to refine how society affects the law, how society's morality is codified in the law. We tell them today, make up your mind. Do you want a jury who is consistent, or do you want a jury who is revolutionary, who is able to make new progress in the realm of law? At the end of the day, we see today, the proposition has left too many questions asked by the opposition unanswered, and therefore, for the sake of law and justice, we'll decide the question.
Since the replies people are so fond of using this room and using the adjudicators as a set piece for the opening of his reply, I shall do the same. Now, let's get a better understanding then of what the adjudicator and the debate will do. They're supposed to act as a layman on the street, an intelligent person who doesn't really know what's going on, but can evaluate arguments. And that is what we are also trying to apply to a court of law. Because we realize, ladies and gentlemen, that after all, verdicts are verdicts. Guilty, not guilty, both inconclusive. Just these three things, ladies and gentlemen. As we explained, all three speakers on our side. Does it require a genius to decide if a person is guilty or not? No, it doesn't. It requires, yes, pretty much a genius to decide how far a person should be sentenced. And that's what we said. That's why we let the judge sentence. But on the question of verdict, no, you don't need a judge. You don't need someone very, you don't need someone too smart. You just need someone who can be guided along the process. And that's what the jury really is all about. So today's debate is basically boiled down to two issues. First of this whole idea of law, what is better for law? And second of all, this whole idea of what is better for criminal. Something which the side opposition doesn't really seem to want to talk about. So first of all, this whole idea of law, what is better for law? So we first tell you that it's good that we have a jury because it better represents what society, when society thinks laws should be applied. And we say that's a good thing. It's a good thing because society owns these laws. These laws affect them. They should not only have the decision to tell you what these laws are, but when these laws are applied, what do they have to say? No, we will not conflate legality and morality. But for the very fact of the matter is, we do that all the time. Something which they have never responded to at all on all three speakers. And then they talk then about this whole idea of consistency, how judges will be better at ensuring consistency. Well, we also tell you, consistency can be ensured when we make judgments. But that's not the question. The question is that when a new grey area crops up, as we've explained all three speakers, when there is a new grey area, what then do we do? Do we leave it up to the discretion of one man sitting on a pedestal, or do we leave it to the discretion of 11 laymen, the people who these laws will affect? I say we give it to those 11 people by sheer virtue of the fact that this 11 people is 11 times less likely to be biased than the individual judge. It's a simple numbers game, ladies and gentlemen. And then they talk about this whole idea of legal trading, and really, ladies and gentlemen, it doesn't require that much legal trading in order to evaluate what is important evidence or not. And we also told you that what evidence is important should be decided by the jury. And so we say, ladies and gentlemen, legal trading is not relevant. And then they talk about this check and balance. Well, ladies and gentlemen, if you're so hung up on check and balance, go to our policy. We have a system of appeals where you can appeal against a decision made by a jury. You can appeal to a higher court, you can appeal to an appellate court. I say that's a check and balance. So what then is their question on check and balance on our side? Now let's then talk about my second issue today, for today. What is good for the criminal? Because we have to understand, we may call him a criminal, but in actual fact, we still don't know yet. He is still in a court of law. We are still determining if he is a criminal. And they don't really seem very interested in talking about that. And all they said is that, well, the judge is better at deciding because he is supposed to be less biased, because he has training. But we say, no, training doesn't necessarily mean you're less biased. Training means you're smarter, but it doesn't mean that you're biased. A lot of people have subconscious bias, as I've explained earlier, which they are not able to suss out. We say that a jury system is better simply because it's less likely that 11 people or 23 people have that same bias all at the same time. And we say that furthermore, it's more important that we have neutrality. Neutrality in numbers and neutrality in composition. Because this means that when you convict a serious crime, that individual who may be sentenced to death, who may be sentenced to 20, 30 years in prison, will not be sentenced there for the wrong reason, will not be sentenced there against the will of society, who may have decided that what he has done does not constitute a crime in the grey area that is present to the law. So we say that for the sheer fact of the matter is this, ladies and gentlemen, the law belongs to the people. That they have accepted. And the law should also protect the criminal from